Yes, so I'm going to discuss on the introduction to criminal justice system, and let's proceed with what really is criminal justice system. Criminal justice system, of course, it refers to various sequential stages through which offenders pass from initial contact with the law to final disposition and the agencies charged with enforcing the law at each of these stages. Also, been defined as a system of practices and institutions of governments directed at upholding social control, deterring and mitigating crime, or sanctioning those who violated laws with criminal penalties and rehabilitation efforts. So, if you try to analyze the meaning that I've provided, it refers to the components of the criminal justice system, and we all know the Philippine criminal justice system is composed of five components or five pillars, mainly the law enforcement as the prime mover, the second one the prosecution, third is the judiciary or the court, and the fourth one is the correction or the fifth one is the community. So, just to summarize it up, that criminal justice system is directly involved in apprehending, prosecuting, defending, sentencing, and punishing those who are suspected or convicted of criminal offenses. Then we have the etymology of criminal. So the word criminal originated from Middle English that came from Old French criminal and from late Latin criminalis and from Latin crimen. Okay, so as you can see, there is a typo, so that should be crimen. Okay, should be crimen or crimen, which means accusation. Criminal refers to a person committed or been legally convicted of a crime. And criminal can be defined in two ways, legal sense and criminology sense. In legal sense, criminal is any person who has been found to have committed a wrongful act in the course of the standard judicial process, whereas in criminology sense, it is a person already considered um, a, a criminal the moment he committed any antisocial act, even without conviction. Then we have the etymology of justice. When we talk about justice, it originated from Greek word dike, which is associated with the concept of everything staying in its assigned place of natural role. So according to Plato, justice consists of maintaining the societal status quo, whereas Aristotle's concept of justice is if there is lack of freedom and opportunity for some people, then he associated that justice with law. So if a person violated the law, he would be considered unjust. Have Lady Justice. So that is the national symbol that represents fairness. Okay, and as you can see, Lady Justice wears a blindfold, she carries a scale, and she also carries a sword. And each of those things represents something. Blindfold represents fairness to everyone. The scales represents the balance in all things, and the sword um, represents defending everyone's right. We have system. Of course, system, it originated from Latin systema or systemat, and from the Greek systema from sunisteny, which means to combine. So system is something that is a combination or to set up and establish. So it refers to group or combination of interrelated, interdependent, or interacting elements. So just like the criminal justice system, there is an interaction among those components. Then we have crime. Of course, crime it is an act committed or omitted in violation of a public law, forbidding or commanding it. And there are three forms of crime. We have felonies, offenses, and misdemeanors. Felonies, it refers to violations of revised penal code offenses refers to those violation of statutes, and misdemeanors refers to violations of city or local ordinances. And we have the three elements of crime. So that is the motive, opportunity, and means. Motive, this is the reason or intent of an individual to commit a crime, whereas opportunity is the chance for an individual to commit a crime at the given space and time. Means, it refers to instrumentality or capability. So it refers to the ability of an individual to commit a crime. And in recognizing and identifying these elements, the commission of a crime may be prevented by taking any one of those three elements that I've mentioned. So that is the essence of crime prevention activity. So there would be no crime if you're going to remove at least one of those elements. Then we have crime reporting. So the definition of this, it's the act of reporting a crime committed. Either it is reported by the victim or concerned citizens to the police and other similar law enforcement agencies or institutions. So usually this refers to figures compiled by the police to depict the picture of a crime. Okay, and as you can see, it is presented in the form of crime statistics. And crime reporting is based on the following. We have crime volume, refers to the number of crime incidents committed in a given area over a period of time, which includes index and non-index crimes. When we talk about non-index crime, those violations of special laws or local ordinances like illegal logging, jaywalking, smoking ordinances. We have index crime, refers to crimes that are serious in nature and which occur with sufficient frequency and regularity, such that they serve as an index to crime situation. So example of index crime: theft, robbery, murder, rape, homicide. So crime rate, on the other hand, refers to crime rate, it is the number of crime incidents in a given period of time for every 100,000 inhabitants of an area. We have average monthly crime rate, refers to crime rate divided into the number of months in a year. And we have the history. History on the development of criminology, forensic science, and criminal justice. So this would just be a brief history on those aforementioned areas. We have the BC years, or before Christ era years. So blood feuds were very rampant during that time, wherein Sumeria has been considered as the first known civilization, and it established the first city-states and governments to help settle disputes. And the Roman military served as the primary law enforcers during that time. And we have the 1st century. Pedanius Dioscorides, a Greek physician that lives in Rome, categorized various plants, their medicinal effects, and symptoms of poisoning. So Pedanius had actually published his work, De Materia Medica, that is considered to be the foundation of forensic toxicology. On the other hand, key and policing concepts were introduced that time, wherein clans were seen as responsible for their members and took matters of crime and punishment into their hands. On 11th century, franklage system has been introduced, wherein all males over the age of 12 were formed into groups of 10 with their neighbors, and they took an oath to capture and detain members of their clans who committed crimes under the supervision of a constable. So those constables in the shire, so that is shire, no? So there is a typo. So constables in the shire were supervised by sheriffs. So those sheriffs were actually appointed by the crown. And on the 13th century, what was introduced on this was, there is this book by Chinese physician. The book was called Shi Duan Yu, The Washing Away of Wrongs. So it is the earliest known work on pathology and death investigation. At the same time, in 13th century, Summa Theologica was being composed by St. Thomas Aquinas, wherein it presented the notion of natural law, wherein it suggested that crime was an insult to God, and that it damaged not only the victim but the criminal as well, because people are inherently good. Then we have the 14th century, wherein justices of peace were appointed by the king to provide support to constables and sheriffs. So here, justices could issue warrants and hold arraignment hearings, and they could try cases that involve minor crimes. What was also introduced in 14th century is parish constable system, and the hue and cry were developed, wherein males were appointed to serve as constables in a town for 1 year. So when a constable called for aid, all men of the town would immediately respond. The call for aid would carry from town to town until a criminal was caught or the emergency ceased. So that is the hue and cry system. And we have the 16th century. It introduced the idea of social contract, in which the purpose and role of the government and the responsibilities of the people and the sovereign were explained. So on this social contract, people ceded their authority to the sovereign in exchange for safety, security, and prosperity. And on 18th century, so here there is a typo, because supposedly this one, so Robert Peel's 9 Principles of Policing, Cesar Lombroso's Positivist theory, this was introduced actually on 19th century. What was introduced on 18th century is the classical school of thought, wherein Cesar Beccaria had published his best-known work on crimes and punishment, and that is a famous essay that is against death penalty and is considered as one of the banished books of Catholic Church, because it had been able to differentiate crime from a sin. And we have the 19th century is what I've said. Now in 19th century, so Sir Robert Peel's 9 Principles of Policing was introduced. And Cesar Lombroso's Italian school or positivist theory has been introduced in 19th century. And on 20th century, Locard established the first real crime lab in two attics at Lyon, France, in 1910. And as we all know, um, Dr. Edmund Lockhart has been considered as the father of crime scene investigation, and he had published his now famous Lockhardt's exchange principle that every contact leaves a trace. So let's proceed with lesson 2 on the foundations of criminal justice. So the classical school is a criminological perspective of the late 1700s and early 1800s, and it had its roots in the Enlightenment period. And we all know that in classical school, its viewpoint is that humans are rational beings, wherein the crime is the result of the exercise of their free will. So let's proceed with the definition of terms. So when we talk about age of enlightenment, this is the age of reason. So this is the 18th century. And on age of enlightenment, here comes the ideas on rationality, free will, which is the concept of classical school. Then we have social contract, wherein it is a concept that human beings abandon their natural state of individual freedom to join together and form a society. So in the process of forming a social contract, people would be able to surrender some freedoms to society as a whole, and the society are obligated to assume responsibilities toward its citizens and provide for their protection and welfare. Natural law, on the other hand, okay, so it is a philosophical perspective that certain immutable laws are fundamental to human nature and can be readily ascertained through reason. And we have natural rights. It refers to the rights that individuals retain in the face of government action and interest. Then we have hedonistic calculus, of course, a belief that behavior holds value to any individual undertaking according to the amount of pleasure or pain that it can be expected to produce for that person. Hedonistic calculus is similar to utilitarianism. Okay, and we have panopticon. This was introduced by Jeremy Bentham. So this is a prison design, which is circular building with cells. We have general deterrence. So this is a goal of criminal sentencing that seeks to prevent others from committing crime. So it addresses the general public. Then we have specific deterrence. So these targets an individual, an offender, not to commit a crime again. You have malainsa naman, acts that are thought to be wrong in and of themselves. So example, rape, homicide. Mala prohibito, on the other hand, these are acts that are considered wrong because they are prohibited. So we have jaywalking, smoking. We have yes, those are some of mala prohibita. Then we have free will. So it's the ability of human beings to purposely and deliberately choose to follow a calculated course of action. So in free will, an individual is a rational actor, and we have the classical school. So one of the famous proponent of this is Cesar Beccaria, wherein he was able to provide two types of proof. We have the perfect proof and imperfect proof. On perfect proof, it's a proof when there is no possibility of innocence, whereas for imperfect proof, it is a proof where possibility of innocence remained. In classical school, it states right here that it focuses on the crime being committed by an individual. It has been said that an individual is a rational being, and the crime is the result of free will. And Cesar Beccaria is being regarded as the father of criminal justice. And as what I've said previously, he was known for his essay on crimes and punishment, which actually condemned torture and death penalty. And aside from that, on that work, he was able to advocate a substantial difference between crime and sin, which resulted with that work being put in the list of banished books by the Catholic Church. And another proponent of classical school, we have Jeremy Bentham. As we all know, Jeremy Bentham, he had invented the panopticon prison, as well as he was able to, I mean, yeah, he was able to advocate utilitarianism and fair treatment of animals. So here on utilitarianism, it refers to a view that people's behavior is motivated by pursuit of pleasure and the avoidance of pain. So it's almost similar to hedonism, wherein a person who seeks pleasure and avoids pain is called hedonist. And that person who is called hedonist calculates or weigh up the costs and benefits of the consequences of each action. So hedonist uses this rational calculator to weigh up the costs and benefits of the consequences of his or her act. And in on as what I've said, Bentham invented the panopticon prison design, and they have argued also that people have free will to choose how to act. And deterrence is based upon the utilitarian ontological notion of the human being a hedonist. And also another argument of classical school, punishment can deter people from crime as the cost outweigh benefits, and that severity of punishment should be proportionate to the crime. So that means the swifter and more certain the punishment, the more effective it is in deterring criminal behavior. So those are the arguments under classical school. But to summarize it up, or just to give a brief summary, what is central to the classical school is the presence of free will. And we have four bases of classical school. Individuals have the will and rationality. Then we have individuals will calculate their rationality based on the benefits. And third one, it addresses the severity of the punishment, wherein severity of the crime, wherein it should be that determined by the severity of the crime to deter others and reduce crime, and punishment must be swift and appropriate to deter others and reduce crime. Then have five principles of classical school. So these are some of the concepts that are related to classical school. We have rationality, of course. It refers to humans having a free will. Hedonism, it refers, or it is related to pleasure and pain. Punishment refers to those justification, wherein if a person committed an unlawful behavior, that person deserves to be punished. And we have human rights. Society is made possible by individuals cooperating together. And society owes to its citizens the respect for their rights in the face of government action. Then we have due process. Due process, it is an accused should be presumed innocent until proven guilty. So in classical school, we have to take note that punishment should fit the crime and it should not be excessive. Then we have neoclassical. This is another school of thought wherein it emphasized deterrence and retribution with reduced emphasis on rehabilitation, and it provides remedy to some problems created by classical school. So in neoclassical school, this theory assumes that those children or lunatic persons should not be punished. So it's a modification of classical school. So in neoclassical, it actually allows mitigating circumstances by looking at the situation in which individual had been placed. Also, it provides some allowances to offenders' past record, and it provides consideration for factors such as incompetence, pathology, insanity, and mentally ill. Then we have the positivist school of thought. So it opposed the classical school's doctrine of free will, and they have considered crime as a product of heredity and environment, that crime is a result of biological and social factors, and the person, not the crime, should be punished. So the punishment should fit the criminal. And criminal behavior is caused by internal and external factors outside of the individual's control. And these are the proponents of positivist. We have Cesar Lombroso, Enrico Ferri, and Rafael Garofalo, which are considered as the Holy Trinity. And positive school, it is another name for this school of thought is Italian school. Then these are the terms associated or concepts associated with positivist school of thought. We have positivism, hard determinism, nothing works doctrine, three strikes legislation, and soft determinism. When we talk about positivism, it refers to application of scientific techniques in the study of crime and criminals. So it has been evident that on positivist school, they use scientific techniques. Cesar Lombroso uses scientific techniques when it comes to studying crimes. And we have hard determinism. It's a belief that crime results from forces beyond the control of the individual. Nothing works doctrine. It's a correctional treatment program which has little success in rehabilitating offender, and three strikes legislation, of course. It's a criminal statutes that mandate life imprisonment for criminals convicted of three violent offenses or serious drug offenses. Soft determinism, on the other hand, is the result of choices and decisions made within a context of situational constraints and opportunities. So as what I've said, positivist, one of the famous proponents is Cesar Lombroso, regarded as the father of criminology, the founder of criminal anthropology as well. And he had published his work, that is The Criminal Man, in the year 1876. He was able to provide or provide three types of criminal: the atavistic, insane, and criminaloid. Atavistic, these are born criminals. Insane criminal, example of this are kleptomaniacs, nymphomaniacs, child molesters. So there is an alteration of the brain among those criminals. Criminaloid, these are habitual criminals who become so by contact with other criminals. And this also includes juridical criminals. So criminaloids include those criminals who are hot-headed persons, or those impulsive persons who commit violent acts when provoked. Then we have, let's proceed with criminal law. So before proceeding with criminal law, just to summarize, classical school, its focus is the crime or the criminal act, whereas for positivist school, the focus of this school of thought is the man and not the crime committed. So when it comes to the classical school, the person is hedonistic, an individual is hedonistic, and the individual has this rationality, and they are morally responsible for own behavior, whereas for positivist school of thought, it is determined by biological, psychological, and social environment, and there is no moral responsibility. And for classical school, the purpose of sentencing is actually for deterrence, whereas for positivist school, their purpose of sentencing is for treatment and reform. So let's proceed with criminal law. This is lesson 3. As we all know, criminal law, it's a branch of law which defines crimes, treats of their nature, and provide for their punishment. So our revised penal code, that is based on classical and positivist theory. So the old penal code, that is the name of the present revised penal code. So this is created under Act 3815, and as you'll know, the revised penal code have these two prominent suppositions. For classical, just to summarize, the basis of criminal liability is based on free will. For positivist, crime is essentially a social and natural phenomenon, and its such cannot be treated and checked by the application of abstract principles. And also, another viewpoint of positivists, the classical method considers the offender as an abstract being and perfects him for him through a series of hard and fast rules, a great multitude of penalties with scant regard to human element. And we have criminal law. So criminal law has three characteristics: the generality, territoriality, and prospectivity. We talk about territoriality, criminal law is binding on all persons who live or sojourn in the Philippines. Prospectivity, of course, it's the concept of criminal law provides that it cannot make an act punishable in a manner in which it is not punishable when committed. So to simplify, crimes are punished under the laws in force at the time of their commission. So territoriality, it states that criminal law undertakes to punish crimes committed in the Philippine territory with the exceptions provided under Article 2 of the RPC. And we have two rules on jurisdiction. We have French rule and English rule. French rule, crimes are not triable in the courts. For English rule, crimes are triable in that country unless they merely affect things within the vessel or they refer to the internal management. We have principles of legality. The principle which declares that for any human conduct to be considered as a criminal act, there must be a specific statute or law declaring such conduct as crime and providing for a penalty. Second one, any human conduct, no matter how evil or reprehensible it may be, cannot subject the actor to punishment if there is no law punishing the act. So just to summarize the principles of legality, this is expressed in the maxim nullum crimen, nulla pena sine lege, which means no crime when there is no law punishing it. So for it to be considered a crime, or for an act to be considered a crime, there should be a law that describes that that certain act is criminal, or crime. Then we have kinds of legal system. We have two, adversarial and inquisitorial. So in adversarial or adversary system, it's a system wherein it advocates or it represents two parties or position before an impartial person. So it's a legal system used in common law countries where, as you can see, there are two advocates, there are two parties, the defendant and offended party, and there is a judge, an impartial person who attempt to determine the truth and pass judgment accordingly. Inquisitorial, on the other hand, the court or part of the court is actively involved in investigating the facts of the case. So this is opposed to adversarial system where the role of the court is primarily that of an impartial referee between the prosecution and the defense. In inquisitorial system, the judge has an active role in investigating the case. And we have process. It's a principle that the government must respect all of a person's legal rights. When we talk about due process, it's an idea wherein legal proceedings must be fair. It has two branches, substantive and procedural due process. When we talk about substantive due process, it is the body of law that defines criminal offenses and their penalties. Example would be the revised penal code. We have procedural due process. It is based on the principle that a court of law renders judgment only after trial and based on the evidence presented therein. So example of procedural due process, it is in the rules of court. Then let's go to the Philippine concept of due process. So we can see this enshrined in the 1987 Constitution. To be exact, this is Article 3, not Article 2. So that's Article 3, Section 1. So Article 3, well, no, this is Bill of Rights. According to that article, no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied equal protection of laws. So the first rights guaranteed in the Bill of Rights are the rights to due process and equal protection of the law. And Bill of Attainder, on the other hand, it's defined as a legislative act which inflicts punishment on named individuals or members of an easily ascertainable group without a judicial trial. To simplify things, Bill of Attainder is a legislative act which inflicts punishment without trial, and it has been stated in Article 3, Section 22 of 1987 Constitution that no ex post facto law or Bill of Attainder shall be enacted. Then we have the perspectives on criminal justice. We have 6 in total. Let's go first with crime control. So It's a model of criminal justice that emphasizes the control of dangerous offenders and protection of society through harsh punishment as a deterrent to crime. Second one, rehabilitation perspective, wherein it is a model of criminal justice that emphasizes the control of dangerous offenders and protection of society, wherein rehabilitation, let me go back, it sees crime as an expression of frustration and anger created by social inequality that can be controlled by giving people the means to improve their lifestyle, and that is through conventional endeavors. We have due process perspective, emphasizes individual rights and constitutional safeguards against arbitrary or unfair judicial and administrative proceedings, wherein an individual should undergo a legal proceedings. That is due process perspective. So there should be fairness in legal proceedings that will be undergone by the individual. Then we have non-intervention perspective. It's a model of criminal justice that favors the least intrusive treatment possible, and this includes diversion and decriminalization. We have justice perspective, of course. All people should receive the same treatment under the law. Restorative justice, it is a model of criminal justice which views that the purpose of justice is to restore offenders back into society. So it involves seeking to repair the harm caused by offender to the victim. Then we have standards of proof. Mere suspicion, it is a standard of proof with least certainty, whereas reasonable suspicion, it's a standard of proof with greatest certainty. Mere suspicion is just a gut feeling, and a law enforcement officer or police officer cannot legally even stop a suspect if it is just a mere suspicion. For reasonable suspicion, on the other hand, the law enforcement officer is legally permitted to stop and frisk a suspect as long as that is a reasonable suspicion, wherein he was able to, I mean, as long as the police is able to articulate reasons for the suspicion. It's more than a gut feeling. We have probable cause, of course. This is what is needed to conduct search and make arrest. And we'll note probable cause, it refers to the determination whether there is sufficient ground to engender a well-founded belief that a crime has been committed and that the accused is probably guilty thereof and should be held for trial. So that is the definition of probable cause. Whereas preponderance of evidence, this is mostly used in civil cases, wherein it is necessary to find defendant liable in a civil suit. So evidence that more likely than not outweighs the opposing evidence or sufficient evidence to overcome doubt or speculation. Then we have clear and convincing evidence. It's a standard of proof in some civil cases and the standard of proof necessary for a defendant to make a successful claim of insanity, and claim of insanity. That is a claim of insanity. Okay, so for beyond reasonable doubt, so this is the burden of proof. Okay, it is a standard of proof necessary to find a defendant guilty in a criminal trial. Then we have criminal defenses, justifying circumstances. These are defense for criminal act claiming that the criminal act is reasonable or necessary under identified circumstances. Under justifying circumstances, the person is deemed not to have transgressed the law and is free from both criminal and civil liability. So these are the kinds of justifying circumstances. So, yan po. So these are the kinds of justifying circumstances. Then we have criminal defenses. We have exempting circumstance, of course. It is a ground for exemption from punishment, for the reason that there is one thing in the agent of crime in any of the condition which makes the act voluntary or negligent. So these are the kinds of exempting circumstances wherein this is a ground for exemption from punishment. Then we have criminal defenses. No? We have emergency doctrine. Of course, emergency doctrine, it holds that a person is confronted with a sudden emergency must make a speedy decision based largely upon impulse or instinct and cannot be held to the same conduct as one who has had an opportunity to reflect, even though it later appears that he made the wrong decision. So that is the emergency doctrine. Mistake of the fact, on the other hand, it's a misapprehension of fact on the part of the person who has caused injury to another. So in mistake of fact, an individual is not criminally liable because he does not act with criminal intent. Then we have doctrine of root of poisonous tree. So it is actually a legal metaphor in US wherein it describes that evidence that is obtained illegally is not admissible as evidence in court. So if the source of the evidence is tainted, then anything gained from it is tainted as well. Then we have insanity. In criminal defense, we have M. Norton rule, Durham rule, Alita substantial capacity test, and irresistible impulse rule. So just to summarize this type of rules, it addresses, or these are excuses used by defendant by virtue or reason of insanity, defect of reason, or mental disease. So this is the summarization of insanity for insanity criminal defense standards. Then we have the 5 pillars, just to summarize on this one. The law enforcement, of course, this is the forefront, the prime mover of the CJS. They are the ones that directly deal with the citizenry and are directly exposed to criminal elements. So a person or offender at this stage is called suspect. For prosecution, the person is called respondent. The offender at this stage is called respondent. And in prosecution, the prosecutors investigates and are causes to be investigated all the charges of crimes, misdemeanors, and violations of penal laws and ordinances with their respective jurisdictions, and have the necessary information or complaint prepared or made and filed against the persons accused. Then we have the judiciary or the court. So a person at this stage is called accused. So it is the final arbiter of controversies of competing claims and interests, including the determination of the guilt or innocence of a person charged with the commission of crime. Then we have the correction. So a person at this stage is called convict, and it involved in the punishment of convicts. So in correction, it is responsible for the custody, supervision, and rehabilitation of offenders. Then the last one, we have the community. Community, of course, the members of the community play a very important role in the CJS. It is from their ranks that the offenders come, and it is with them that they will end up. So the involvement of these people or institutions in the programs and projects of the government, even those that are not necessarily connected with the administration of justice, contribute. So community definitely contribute to the lessening of crimes as their efforts are diverted to more productive matters. So a person or the offender at this stage is now called ex-convict. So that would be the end of the discussion on the introduction of criminal justice.